What's going on, TEI family? I thought I'd check in with you guys today, talk a little bit about intellectual property, specifically trademarks. I was on the phone with a prospective client today. He's like, "Man, hey, uh, I'm trying to actually trademark my business name," and he had a phrase or whatnot. And he, gave me the phrase, and I'm like, that's kind of going to be tough to trademark because just a descriptive mark. It describes the services or the products that you're selling. And I kind of was thinking to myself, like, man, I need to make a video on this. I know everybody thinks that whether you're trying to get a trademark or you have a trademark, that all trademarks are created equally or all trademarks have the same strength, and that's just simply not true. You have whether it's a short phrase or a logo, you have those that are uh, generic and therefore do not afford protection. And then you have the strongest type of trademarks, which we would say are fanciful marks, and they are going to get the most amount of protection. Now, again, that's especially when you have the trademark, when you actually have a registered trademark, and say, for example, somebody tries to sue you, you're going to find out very quickly in court the strength of protection that that mark has or is going to be afforded. So again, I think this is going to be an important video for people who are looking to get a mark, so that when they're thinking about uh, a word or a phrase to come up with to be used as a trademark, they can kind of make sure they're going about it in the right way and thinking of something that's going to get them the most protection as possible. But then, even if you do have a registered trademark, this is something to keep in the back of your head. For example, maybe if you do end up in court or not, you kind of maybe have an idea of how strong your mark is. So you typically have five categories, or the way the courts in the USPTO see it, you have five categories of marks. You have a generic mark, you have a descriptive mark, you have what is called a suggestive mark, you have a arbitrary mark, and then you have a fanciful mark. So those are your five categories that the USPTO and the courts are going to put your mark in. They're going to put your mark in one of those buckets. Now, you should be aware that generic marks and descriptive marks are not, you can't register generic marks or descriptive marks with the USPTO. You're not able to register your mark as a trademark, and it has to get to that suggestive. It has to be considered at least a suggestive mark for it to now be afforded protection by use of a trademark with the USPTO. And obviously, you have suggestive marks, you have arbitrary marks, you have fanciful marks. All three of those type of marks are afforded protection with the USPTO. The fanciful marks being the strongest form of protection. Think of that as the strongest form of protection. Then think of, again, your generic is the weakest form. You're not going to be able to get uh, any type of protection or trademark on a generic with the USPTO or the courts consider a generic mark. And if, for example, you do are able to register a mark, but then you end up in court and the court says it's a generic mark, hey, you're going to be in trouble. So let's start with generic. What is considered a generic mark? Think of aspirin. Everybody, when they have a headache, they say, "Hey, can I have some aspirin?" They may be talking about Tylenol. They may be talking about an Aleve, but uh, the word aspirin has become so generic, such that anytime somebody has a headache, they say, "Hey, give me an aspirin." Just think of a car, for example. When they say, "Hey, I just got a new car recently," they say, "Hey, what type of car do you have?" You can have a truck, you can have a sedan, you can have a SUV. It's subsets of cars, but when you think of the word car, it's so generic to these other subset of cars that that's not going to be, if somebody was to try to register or get a trademark on the word car, that's not, it's just so generic that the USPTO is not going to allow you to get a trademark on the word car. So that's some examples of what a generic mark is. Let's go to the next form of protection, or not the next form of protection. Let's think of the next group that the USPTO and the courts put these marks in, and that's a descriptive mark. So I think this is probably going to be the easiest type of mark because it just describes the nature of the service. It's actually, when I was talking to the prospective client today, again, like I said earlier, his mark was descriptive, and I was saying, hey, you're probably not going to be able to file a trademark application and get a trademark on that particular phrase, because it's pretty much it describes the nature and the services of it describes the nature of the goods and services that you're performing. So think of the U.S. News Report. they're not going to be able to get whoever owns the U.S. News Report is not going to be able to get a trademark on that name because it describes the services. Uh, it's it provides news to the U.S. Again, it describes the services of the mark, and therefore you're not, at least at the beginning, going to be able to get protection from the USPTO, which is the United States Patent and Trademark Office, on a descriptive mark. Now, you can a descriptive mark can acquire you can get protection later on through what is called secondary meaning. And pretty much what that means is just over time, you being consistent, you consistently using a mark, the public has they when you say what that mark is, they know the product or they know the service that mark is attached to, just because it's such a popular mark with consumers that later on you can potentially get or acquire trademark protection, even though a mark was initially considered descriptive. So again, keep that in mind. I'm not going to kind of go into too much detail outside of that, but just keep in mind that a descriptive mark in and of itself is not going to be able to get trademark protection at the beginning, but over time, it can potentially get a protection from a trademark standpoint with the acquisition of what is known as secondary meaning. So again, generic marks, descriptive marks, in and of itself, they're not going to be able to they're not afforded trademark protection. So let's go to the next level, that now you're starting to get, some trademark protection. And that's a suggestive mark. A suggestive mark, think of like Netflix. You have the words net, which, it's like the internet. Okay, okay. And then you think of flicks, you think of pictures, you think of videos, flicks. When you put them together, Netflix, it suggests the nature of the services or goods, but it takes this kind of imagination. So when you think of Netflix, you think, okay, internet streaming, internet videos. The user have to come, they have to use their imagination to kind of think of what this mark, what's the nature of the goods and services of this mark, Netflix. So again, those suggestive. Once you hit that type of mark, now you can file a trademark application, and the USPTO will allow you to protect or have a trademark protection on suggestive marks. Then the next form, which is even, you have a stronger form of protection from suggestive, is arbitrary. So I think the easiest way of an arbitrary mark, think of Apple. If Apple was selling fruits, or they had a restaurant selling fruits or a farm selling fruits, selling apples, they're not going to be able to get a trademark on the term apple because it'll be considered a generic mark. Or it can also be considered a descriptive mark. It describes the nature and the services of the goods, which are apples. But the fact that they're using this word apple, which is a word, which is an actual word, apple, and when you think of an apple, you think of fruits, and they're using it for a arbitrary or a random use, which is electronics. You don't think of, not now, you probably do, but initially, before Apple was around, you didn't think of the word apple for electronics. So when you have this arbitrary use, when you use maybe a word or a phrase that's already out there, and you're using it for something completely different than what consumers or the public would ordinarily think of that mark, that's going to be considered an arbitrary mark, and therefore it's going to be, obviously it's going to have trademark protection, and the strength of that trademark protection is going to be just a bump of a suggestive mark, which we talked about before. And then the strongest form of protection of a trademark is what is known as a fanciful mark. And what that pretty much means, it's a made up word that is actually being made up for the strict purposes of trademark protection. So think of Exxon, which is, I think that's the oil company, Exxon. That word Exxon does not exist in the dictionary, and it was made up for the specific use of the company, for oil services, things like that. Think a lot of these drug companies where they have this kind of weird drug that they have a trademark on, and that name of the drug, which, more times than not you can't even pronounce, that name was specifically created to get trademark protection on that particular drug. Those are going to be the fanciful marks that is going to afford the strongest protection with the USPTO and by the courts. And again, it's essentially a made up word that has been made up for the strict purposes of trademark use. So again, hopefully you got something out of this video. You understand the different buckets that these marks are going to be put in. Again, the generic marks and the descriptive marks, which is not going to be afforded trademark protection. With regard to the descriptive marks, you may be able to get that later down the line through what is called secondary meaning, but on at the beginning is not going to be afforded protection, and then you start to get some form of protection, or you're able to get a trademark once you hit that suggestive bucket, I'll call it. Then a suggestive mark, an arbitrary mark, and a fanciful mark, you're going to be able to get protection on. So hopefully, as you're kind of thinking about the master plan, you're thinking about, okay, I have to protect my IP. I have to think about my name or phrase. Hopefully, you kind of start at that suggestive mark, something that's at the minimum suggestive and it requires just imagination, because you're going to, number one, be able to get a trademark on that. And if that trademark is later challenged in court, that it's going to pretty much hold up because it has this is more than descriptive and generic. Then once you start to get arbitrary and fanciful, you're really on your way. So hopefully you got something out of this video. Leave a thumbs up if you did. Leave a comment. And until next time, TI family, peace.